Criminal justice administrators and supervisors, especially those who implement policies, have the potential to exert a tremendous amount of legal authority over citizens. Given this, it should come as little surprise that legal actions are routinely initiated against these actors, and often it is not uncommon for citizens to allege that their constitutional liberties have been violated. There is the potential for liability for criminal justice executives whenever they engage or fail to engage in acts such as hiring, promoting, disciplining, and training the criminal justice personnel they are paid to oversee. This presentation shall examine various issues associated with liability and will include a discussion of possible remedies and solutions to avoid and mitigate areas of liability. First, it is important to point out that Section 1983 lawsuits have been the primary vehicle by which administrators have been sued for violations of constitutional rights. Every criminal justice administrator and supervisor should be familiar with Section 1983 lawsuits. As a reminder, a plaintiff who files a Section 1983 lawsuit alleges that the defendant must have acted within the scope of his or her authority or under the color of law. Also, there must be an alleged violation of a constitutional right. And, interestingly enough, governmental entities can be liable for constitutional deprivations. In his book, Civil Liability in Criminal Justice, Professor Darrell L. Ross points to the landmark U.S. Supreme Court case Monell v. Department of Social Services of the City of New York. The Monell decision opened the floodgates for lawsuits filed against municipalities. The ruling essentially established that a municipality can incur liability anytime criminal justice administrators implement policies, regulations, or customs, or fail to enforce these. For example, if an administrator repeatedly does not enforce a use of force policy, then this becomes a custom which exposes an organization to liability. Also, a governmental entity may be liable in situations where authorized policymakers approve of or tacitly condone a subordinate's unconstitutional action or decision. So, under the Monell decision, a supervisor does not need to directly participate in an unconstitutional act for there to be liability. As a legal strategy, plaintiffs will often sue upper echelon administrators. Why do they do this? The answer is simple: money. The higher the position of the defendant, the closer the plaintiff gets to the deep pockets of the county or state agency. Yes, a plaintiff will sue the individual criminal justice employee who deprives him of a constitutional right. However, the plaintiff will also sue the employee's supervisor or the agency administrator because this is where the money is. And remember, under the Monell decision, plaintiffs want to sue municipalities as this is where the money truly is. Generally, whenever a plaintiff files a Section 1983 lawsuit against an administrator, supervisor, or a municipality, it must be shown that the defendant engaged in an act of deliberate indifference. While the court has not explicitly defined deliberate indifference, it has been suggested that deliberate indifference is likely to occur whenever an actor consciously chooses a course of action with disregard for a harmful outcome of which he was aware or should have been aware of. If an administrator can show that she responded reasonably to known risks, this may help to curtail civil liability. There are many administrative actions that are subject to lawsuits under Section 1983. One example involves negligent hiring, where a plaintiff essentially alleges that a criminal justice administrator fails to perform a complete background investigation of a law enforcement employee. If it can be shown that an employer knew or should have known that a job applicant was unfit, yet the employer hires the applicant anyway, This opens the door for liability. Usually, whenever a Section 1983 lawsuit is filed against a governmental entity for negligent hiring, the defendant typically tends to be a small town police department. The plaintiff must demonstrate that he or she suffered an injury as a result of negligent hiring practices, and he or she must establish a connection between the background of a particular applicant and the injury. This is a fairly high legal standard. However, cases have prevailed in favor of plaintiffs. As a result of the very real possibility of being sued, managers of criminal justice personnel have become aggressive in conducting thorough psychological examinations and background checks on potential employees. It is recommended that employers obtain a notarized waiver from applicants, which provides investigators to access all aspects of an applicant's past. While the candidate must be informed that any findings will remain strictly confidential, it would nevertheless be prudent for the candidate to sign a release of liability prior to conducting a thorough background examination. There is also the potential for administrative and supervisor liability to arise whenever a plaintiff claims that an incompetent employee was knowingly permitted to remain in his or her position. For example, courts have imposed liability in situations where administrators have had foreknowledge of a subordinate's mental unfitness, yet still permitted the officer to remain in this position. If an administrator believes that there is a foreseeable harm, then efforts must be made to remove the incompetent employee from this position. Of course, out of fairness to the employee, efforts should also be made to train or provide support depending upon the situation. But incompetent criminal justice employees cannot be negligently assigned, since there is simply the potential for too much civil liability. Criminal justice administrators can also be sued for negligent entrustment if they permit employees to misuse equipment or misuse physical force. The test of liability, again, will be deliberate indifference, and plaintiffs will need to show that supervisors knew or should have known about the negligence of their employees or prospective employees. There are situations when criminal justice administrators fail to direct, which means they essentially do not inform their subordinates of the special requirements and limits of the job to be performed. This is very much related to failure to train, which shall be discussed in a moment. But the takeaway from this is that it is an excellent idea for administrators to establish and maintain a current, comprehensive, and constitutional written policy manual. Also, agency procedures should reflect written job descriptions, and it is imperative that administrators not shut their eyes to or tolerate improper employee conduct of any kind. All complaints of improper conduct should be investigated, and employee performance evaluations should be conducted. These are ways that criminal justice administrators can reduce their exposure to civil liability. Several scholars suggest that failure to train allegations are among the most common types of claims brought against criminal justice administrators. Inadequate training may serve as a basis for Section 1983 liability when a failure to train amounts to deliberate indifference. Only when failure to train reflects a deliberate or conscious choice by a municipality can a city be liable for such a failure under Section 1983. Generally speaking, one incident of improper training will not resolve in liability. There needs to be a pattern or history of problems related to improper training. It is worth noting that the standard of deliberate indifference is a high hurdle for plaintiffs to overcome when asserting a training deficiency. Plaintiffs who file lawsuits based upon a failure to train must establish that the agency adopted a practice of training that violates a person's constitutional rights. If this can be demonstrated, then there may very well be liability, even if there is only one alleged incident involving improper training. Interestingly, there are situations where criminal justice employees themselves become plaintiffs and file lawsuits against their department for failing to train them. For example, suppose a police officer is involved in a deadly use of force and sustains a serious injury. Could this criminal justice employee successfully sue the department on the basis of not being properly trained for this incident? The answer is probably not. Generally speaking, courts have ruled that the mere failure of a criminal justice agency to adopt a special training policy for special events does not form the basis for liability. Having said this, academy and in-service training instructors have moved toward instituting more scenario-based, real-life training scenarios. But what happens when the training becomes too realistic and even unsafe? If a criminal justice employee is injured during the course of a rigorous training exercise, can he or she successfully sue the department? The answer is, it depends. If it can be demonstrated that an unsafe training environment clearly existed and that the reasonable precautions were not taken, this can increase a department's exposure to liability. A training exercise should never become a free-for-all where participants can sustain serious injuries. Courts determine whether or not a criminal justice agency's policies and training are unsafe based upon a case-by-case basis. Deliberate indifference will again be the legal standard that courts use when assessing whether or not an organization's training policies are unsafe. If an injury that was sustained to a training exercise was foreseeable, this increases the likelihood that there will be liability. It would behoove criminal justice administrators and supervisors to begin to make an effort to train their employees in the handling of persons with disabilities. One growing area of litigation involves plaintiffs with mental illnesses. The literature indicates that only these criminal justice employees may in fact have difficulty identifying and adequately responding to individuals with mental illnesses. For example, a person who is in a state of crisis may be incorrectly identified as a criminal and even be the recipient of improper use of force. To curtail liability, criminal justice organizations throughout the country have begun training police officers in this area. Interestingly, the Memphis Police Department has been one of the national leaders in providing such training. And it is important to mention that new training must accompany emerging law enforcement technologies. Electronic energy devices, such as tasers and stun guns, have been the subject of considerable litigation. If a defendant can show that officers are routinely being trained with the latest technologies, this is likely to reduce liability.